Cannabis Common Sense, the show that tells the truth about marijuana and the politics behind its prohibition.
Hello and welcome to another exciting edition of Cannabis Common Sense. We have a very interesting show for you tonight. We have an attorney from the East Coast. His name is Eric Postow, and he's with the Holland Law Group. And he's been defending a case in Maine against a Maine adult use and medical license holder, where he has been, the defendant has been charged with a federal crime. So he's defending him in federal court. We'll go into that in a lot more detail in just a moment. But first, let's bring on our infamous dancing cannabis lead.
I feel the force.
If you are a loved one, are looking for help finding a physician or a doctor who can help you get a medical marijuana permit, then we have a referral. You can call us at 503-235-4606. That's 503-235-4606. Stay tuned and keep working to restore him. Good night. I'd like to introduce Eric Postow of Holland Law Group in Virginia, who's been involved with cannabis issues for several years. I notice your law firm, Holland Law Group, has been involved with marijuana politics and issues. Can you kind of describe your practice and what brought you into the cannabis field?
Thank you so much, Paul. Yeah, it's Hold On Law Partners. We're a national virtual law firm headquartered in New York. We have offices in Denver and Washington, D.C., here in Virginia, and a number of other states. To be honest, our firm is a heavily regulated industries firm, emerging markets oriented. We provide a lot of outside general counsel distributed services, whether it's complex litigation or deal making, M&A, and things like that. A lot of IP and supporting business clients and clients that need more sophisticated counsel. Our origins, though, are certainly in the cannabis space. The firm really did start out as a focus area in cannabis broadly, diversified into hemp, and that we really just started to see that we were well equipped to work in spaces where it's underregulated, where the laws are in flux or the rules are kind of emerging because it's new, where the states are not all the same, lack of uniformity. And so we thrived in the cannabis and the hemp space. We're in a lot of emerging technology and AI spaces as well. So yeah, but our roots are definitely well set inside a lot of the cannabis industry spaces and in the courtroom, defending and advocating in the current environment.
Well, that's what I found out about your practice, and one of your clients here in it's Portland, Maine, correct?
Yeah, so I think you're referring to a case that we litigated out of Bangor, Maine, and the clients were out of Farmington, a licensed medical marijuana business, and we supported them through criminal indictments and prosecution for over 5 years. Recently, finishing up the jury trial, the verdict did not go our way, but we're still very much involved in that case. It isn't over yet, but yeah, I think that's what you're referring to.
Yeah, it's a fellow named Scott, and what's his last name? Scott. I don't have it.
No, Scott. Yeah, so the client's name is Luke Soroy.
Luke Soroy, I'm sorry.
That's okay. And Luke Soroy, he's an entrepreneur. He's a cannabis entrepreneur. He's been a licensee for 15 years in Maine. Started out as a caregiver when the small grow. Scaled that business over time, and it was his facility that was raided on July 21st, 2020 by Joint Task Force of DEA, FBI, state police in Farmington, Maine. And I've been involved in the case since July of 21, where I really got to know what happened here and was able to work through a variety of different mechanisms to tell the story from the defendant's perspective and hold the government accountable in different procedures and hearings along the way. I'm happy to provide more context, but I think that's
Please
enough of
do.
an overview.
We've got 50 more minutes to go, so we've got time for lots of context here.
Yeah, well, I can either just talk or you can ask a question and I can
Go ahead.
answer
If
your
you've got
question.
more to say, just keep talking. Or I don't know much about the case. I
Yeah.
heard about it. I was on a panel at the Boston Freedom Rally in September, and I
Yeah.
shared the panel with Glenn and Catherine Lewis, and they made me aware of the case.
Gotcha.
And so, and they gave me your information. So that's how it came about.
All right.
I don't know a lot about the situation in New England or the East Coast in general. I'm a Oregon guy.
Like many places, the laws and regulations around medicinal marijuana have changed quite a bit over the last 15 years. The marketplace has picked up, and entrepreneurs who worked within that have grown their businesses just like anywhere else. The reality of Luke's case is that it shows the incoherence of our entire system, okay? For framework, we have federal illegality, and since 2018, federal legality of the same plant, and state legality of the federally illegal version. What could possibly go wrong, right?
Right, right.
So the state invites citizens into its program to come out into the floodlights, as it were, to say, here I am. And the state says, we want you to violate federal law. Okay?
Mhm.
They license these people, these individuals, these businesses to cultivate, manufacture, and distribute a Schedule I controlled substance, marijuana. There should be no mistaking what the states are not just encouraging, but are participating in. They are actively participating in something that violates federal law. That's important, okay? Luke took advantage of that opportunity, and since 2010, held a license, grew those businesses, provided the medicine that people were looking for, and ended up with probably at the time in 2020, one of the most recognized participants in Maine's medical marijuana space, and well known in the state legislature, advancing policies like track and trace. He believed in bringing in a system where you could, from seed to sale, track what's going on, which would provide reliable data to the state and to businesses alike. And all the while, he worked with reputable professionals to help scale and build these businesses, law firms, lawyers that help design compliance programs that would fit within the law, professional accountants. He's no accountant, right? He's a guy that understands cannabis plant and how to work within that market space. And not unlike many cannabis entrepreneurs and businesses, the cannabis people come in all shapes and sizes. Some of those people are more reputable and above board, and some of those people, are not. And I think that is a sign of the times, that the legitimacy of the whole industry comes and works its way out to get rid of bad actors within the spaces. But as a business that's growing, sometimes it's hard to know who's out there, doing good things and who is not. Enforcement is an oversight. It's a wonky relationship between the Office of Cannabis Policy and the licensees. I think that there was a lot of dynamic in Luke's case. The OCP knew Luke, had a pretty good relationship with Luke, came in, provided the oversight, cited minor things, got them fixed, and in general, never really cited for material defects in compliance. In 2020, the law enforcement, federal, state task force, started to look at Luke Soroy because of a conspiracy that some members of the conspiracy, who were small circle of caregivers growing marijuana for whomever, were also trading that marijuana with someone in New York for cocaine. So there's a little conspiracy going on somewhere in Maine. One of those guys wanted to go legit and supplied a resume to Luke Soroy and went to interview for a job in the tissue culture. By virtue of that conversation, by that connection, the DEA said, and the FBI, all the folks that were involved, the task force, there's a conspiracy, and that Luke is the upstream provider for this cocaine thing. So they made the whole thing about this cocaine scenario. And that was really what the complaint spelled out this very, elaborate conspiracy to distribute marijuana and do it for cocaine and so on and so forth. The problem with the whole thing is that it was completely made up.
Mm-hmm. Did Luke,
that little ring.
Yeah, did Luke hire that guy?
It was so early on in their communication that I don't know if it ever actually, the guy got hired. Like, if he got hired, it was within a week or two that the bust happened and the raid and all this stuff. So it was incredibly early on. And what was interesting is
this guy came in and asked for a job and gave a resume and talked to Luke.
Yeah.
And then a week later, the feds busted Luke for talking to
some short amount of time later. They connected him that way.
Was this guy wearing a body wire or any kind of?
No.
Was he working for the court?
No, he wasn't. He wasn't. He was just some guy that got caught. He was caught. They had done controlled buys on him. They knew what he was doing.
Mm-hmm.
They targeted Luke.
Mm-hmm.
They targeted Luke. They knew what this other guy was doing. Because Luke was their target, they just coupled him with them. 2 years post indictments, by the way, around 2022, 2023, that guy entered a plea deal and proffered. And in that proffer that was accepted by the Department of Justice, he said, Luke had nothing to do with what I was doing with this cocaine stuff. And all but cleared Luke of the massive conspiracy that it was, and that the DOJ regularly published and said this is what was happening. And it was just completely not true. and that was the story that people believed. And it's really unfortunate how they do those types of things. And I caveat with, we're still very much working on a lot of these issues, and we're going to expose everything that happened, because what happened under the hood is far worse than what I'm describing. What happened under the hood is local law enforcement that had a bias for Luke Soroy had put a target on him, had been stuffing a file filled with unrelated drug busts from all over the region, all over New England, making it look on paper like this guy was connected to every kind of thing. None of it was true. None of it was true. None of it had anything to do with him. But since 2010, when a particular member of law enforcement got a warrant, kicked open Luke's door to find his marijuana grow, only to find out after it was licensed and legal under state law. Something that he could have found out before he kicked open the door, before he made a sworn affidavit saying that this guy is doing this something, okay? So that is where this kernel starts. One person, one member of law enforcement who has a target on Luke, who misidentified him as a criminal, who kicked open his door only to learn that this was a licensed operation, but kept building a file against him for years. And then the sworn affidavits that went to the court for search warrants and wiretaps, they described Luke Soroy as a known trafficker. They did not describe him as a known licensee.
Right.
All of the stuff that had built into that file that had created this character behind the scenes, which none of it was true, was now being presented, coupled with a conspiracy that wasn't happening. And in the end, they maintained their prosecution, the Controlled Substance Act claims, with the evidence of him being a licensed business. All of the evidence presented, if you were to go and look at the trial record, 95% of it is the same thing that any licensed medical marijuana business anywhere in the country would have been found guilty of, for violating federal law, possession, intent to distribute, or conspiracy to do the same, or both. And that is what's problematic here. And there's a lot more details of like the mechanics that we went through and how we exposed a lot of these things along the way that kind of shifted the battle space inside that courtroom. But I think it's important to know that any licensee can be targeted, can be coupled with a fake conspiracy, a false conspiracy, a manipulated conspiracy, and the underlying issue is you're violating federal law. So even if none of that was true, we can still get you for the violation of federal law. And therein lies the incoherency of all of this. You can't have it every which way. You can't legalize, keep illegal, legalize the illegal version, and expect any sane outcomes.
In that jury trial, you could not bring up his license, and you couldn't talk about medical
That's correct. The state legality, the fact that he was a licensed business, was no defense to violations of the Controlled Substance Act. And so we were not allowed, we were not permitted to explore those. We did what we could with it, but we really weren't able to do that. And so, some of the folks along the way would have said like that, well, the only way you can defend is to go for jury nullification. And the court, rightfully, I think, took that away from us because it isn't a defense, though it's contextually relevant. It's not a defense to the federal law, because federal law trumps state law in federal court in that sense. But it just exposes we get a serious problem with how our laws are structured right now. And those in the trap, which is all of us, are the unwary, seemingly unaware of how completely moronic and dangerous this whole thing is. How many lives get upended by that, by a situation like this, where the stuff that they were really after, they really wanted to stop that interstate drug trafficking, cocaine stuff, all of those things. It just, none of it was true. And that's unfortunate. And that's where you what you're really doing is seeing the marriage of the desire of a biased local police force, and it's biased. And we're going to expose that. It was biased, and there are individuals who will be held accountable for what they did. And I'm talking about serious, egregious, misconduct. To give you a quick example, we had an evidentiary hearing. The evidentiary hearing was built around our motion to stop the prosecution early on under Rohrabacher-Farr, which I'm sure you're familiar with. Yeah. Rohrabacher-Farr said, because it doesn't exist anymore, and I don't think it actually meant anything anyway, but what it said was the Department of Justice was prohibited from expending any appropriations on licensed medical marijuana stuff, on patients, on doctors, on the entrepreneurs, on the state officials, all of these things. Can't spend any money on that. Well, in their, again, sworn affidavits and all the documents to get warrants, to get wiretaps, they wrote a footnote. Rohrabacher-Farr does not apply because cocaine.
But Luke didn't have anything to do with the cocaine.
It had nothing to do with the cocaine. The cocaine was a false flag, put it to you that way. False flag, not real. Very easily to verify it wasn't real. It's super easy. But nonetheless, that's what they used to get around the restriction. When we're talking about compliance in cannabis, don't you think the government ought to be strictly compliant with rules that restrict its power relative to the citizen? Yeah. So that is a big problem also, that this manipulated, convoluted conspiracy entanglement that wasn't true ended up being the thing that could get around the thing that stops them. Get into the evidentiary hearing, and it's a challenging spot for a defendant to find themselves in, because what you want to be able to do is just demonstrate substantial compliance and have Rohrabacher work. That is a very amorphous, squishy thing. How much is substantial compliance? How much is compliant enough? In our minds, compliant enough were the things that really should have been, addressed by the state. And if there was no black market stuff, then there really wasn't a major compliance thing, and what are we doing here kind of thing. But the defendant has Fifth Amendment rights, and there is a criminal proceeding hanging in the balance. And so we really couldn't put on all of the case that we might have wanted to put on at that time. And so what we did was we largely just destroyed the government's case at that moment in time on cross-examination. And we felt like we had done enough to prevail on Rohrabacher, because a lot of the underlying things were blown up, all those conspiracies to do stuff. But kind of felt like in the end it ended up just being a probable cause, kind of a standard, like more likely than not, preponderance of the evidence, not enough for a federal district court judge to grant the injunction to stop them. And we took that through appeal in the First Circuit, lost, all the way up to the Supreme Court of the United States, denied cert on the Rohrabacher-Farr concept. But what it also allowed us to do was to tell that story a few different times. And if you were to read all of the motions and all the briefs, you would see what's going on here was that they had unfairly targeted this licensed person. And in the evidentiary hearing, their lead investigator was cross-examined on a sworn affidavit of his, whereby he took a recorded call between father and son, Robert and Luke. In the call, they were discussing Robert's Christmas tree sales and his JP Morgan stock portfolio. And the investigator described it in this sworn affidavit as a drug call, that it was about marijuana sales. And I learned a lot about how the process works in these investigations, and it's interesting. Basically, you got the wiretap, and you got the police listening in, and they make a line sheet. They describe what they're listening to. If you read the line sheet, but you didn't listen to the call, you'd only know what the line sheet told you. So if the line sheet told you they're talking about drugs and you didn't listen, if you're a prosecutor, you wouldn't know that that was completely fabricated. And so that's what happened. And the reality is that was the one that we described in cross-examination, and you didn't look so great. But there were more. There were more throughout the record, where it seems to me to be intentional manipulation. You didn't get what you wanted, so you needed to falsify the record a little bit. You needed it to look worse than what it was. Otherwise, you can't justify going to the next step in the investigation process. Can't get the next wiretap. Can't get the next search warrant. Can't get the indictment. Can't get the criminal complaint. And again, that is very problematic, that our system can have that kind of corrosiveness underneath it. And that while we're here talking about, cannabis and marijuana, it's really much deeper than that. It's really about how we relate to one another. How does the government relate to people? Well, criminal justice should be balanced and fair and objective, and certainly, aware of its own bias, which there's a lot of in the marijuana space, right?
Mm-hmm.
Times are changing. Bias is not.
Yeah.
The marijuana people are the bad guys. They're the drug dealers. This is the conditioned, response, and it's pervasive, and it's leading the good guys to doing bad guy things, i.e., falsifying records, making material misstatements in sworn affidavits so that they can get the bad guy, right? Make up stuff about them just enough to get over the line so that you can convict them for the thing that you really shouldn't have been able to convict them for in the first place. Put it to you this way. If the case that they put on at trial was the same case 5 years ago, they don't even charge them for that stuff.
Mm-hmm.
But because
this is a new development from this current administration.
Say, what's your question?
Oh, this is a new development. You're saying 5 years ago, they wouldn't have charged this because of the Rohrbacher.
What I'm saying is that they charged something that did not hold up. And what they convicted on was the thing that if all they had 5 years ago was what they prosecuted in the trial, they never would have brought those charges, and Rohrbacher Farr certainly would have stopped them. If there was no cocaine conspiracy, okay? If there was no massive sprawling criminal enterprise upstream provider concept, if it was just, this is a licensed business, and maybe they have some compliance issues, and maybe they fall under the collective issue that has never been decided by a state court. That was one of the big compliance things, is they said this guy is a prohibited collective. All right. Well, Even still, isn't that something the state
Yeah,
should
that's
figure
a
out?
state issue. It has nothing to do with federal
What
law.
makes that so important that we need to take it up in the federal courts and federal prison and all of this nonsense over whether something is or isn't a collective, which is an incredibly wonky technical question of which Luke Roy had been advised by counsel looking exactly at that thing, and they designed it to work within it.
Mhm.
That's just so that's the system at play here. The victim in that is Luke. The state invites him to violate federal law. He works with the attorneys to figure out how to be compliant. Someone says it's not compliant. Federal charges. Why? Because of made up conspiracies. That's not good.
No, it's terrible. It's terrible. And for all the other licensees in the state, that bodes ill. They could go after anybody with some made up guy.
Anybody they
And
want, and you got the the U.S. Attorney's Office there backpedaling, saying, we're not coming after. He was violating state law. Bullshit, nonsense. The state law stuff was de minimis. It was minuscule. It was easy for the state to have handled that. If the state thought it was a prohibited collective, they could have cited him for that. They could have taken him through his due process, and they could have determined it was a collective or not. And if it was a collective, they would have recommended changes, and he would have changed to fit the law. That's how the process should have worked. So we are talking about just utter nonsense out of that U.S. Attorney's Office when they are trying to suggest, well, he was violating state laws. No, he wasn't.
let me ask you this.
Not really.
Did they try forfeiture actions against Luke for property?
Oh yeah, we still have a civil asset forfeiture case that we're going to have to address.
My experience is that is their main motivation. If
No kidding.
your client or the defendant owns anything of real value, that's the motivating factor for law enforcement. So obviously you mentioned,
But I
we
believe
didn't
that
talk about how
100% in this case.
Luke and his father are both now convicted under this, but they were just talking about their stock portfolio. That's something you mentioned. So obviously did they go after that too? Or can you say?
They have liens on a lot of their properties, and they ruined their lives, and they stole their money through their bank accounts. Oh, and they still have to pay their tax bill for the quote unquote ill-begotten gains. I mean, the system is rotten in this whole thing. Yes, civil asset forfeiture has everything to do with that. They targeted the big show. They went after the person who was successful, who was out in front, who was leading the pack, who was known, open, and notorious. And because of questionable compliance, and when I say questionable, I mean it should have been determined in a state agency, administrative hearing, and or a state court on what whether that collective was or wasn't. The First Circuit Court of Appeals, the District Court said, well, it's a collective, but I don't think that they got a chance to review it fully. One, because we were strategically, we were not able to go into it as much as we wanted to, given the context of there's a criminal case here, and it was just challenging. We were dealing with a lot of different things, but the primary sticking point is that they associated financial arrangements with making it a collective, and the collective language of Maine's law was about physical support, not financial. So they added something into that's now what a collective must be. But I think that it's worth it. It would be worth it in the state to go clarify what a collective is, what a prohibited collective is, and what it's not. And I think that's just some bad law there that needs clarification, because it can easily be misinterpreted, or you could have a court decision that is not what you intended it to be, and not how it's written. So nonetheless, I think that there's some challenge with that, but that stuff is what the state should have figured out.
Mm-hmm.
Not all this other stuff, but there's this entanglement between the federal government and Maine law enforcement that's very bizarre up there, and
they want that money. They want it
Why?
for
They want the money.
their own vacations and their own police department. And they want,
Well, they want the money because money funds all things, and there's no doubt about it. There's a great, it's not great, it's a terrible story. That same law enforcement officer, I said that busted, Luke, had a previous run-in with Luke's dad, and a year or so before that, and my understanding is that it was a warrantless search, and he found a little grow, and Robert, agreed to plead guilty to that based on ineffective counsel. But the part of the story that has me is, after Luke gets, clarifies to this member of law enforcement that it's licensed and he has to close the case, he says to him, the law enforcement guy says, "Say hi to your dad for me." His dad was sitting in jail at that time.
what a bastard.
You're not telling me that's not personal?
Yeah.
There's not a personal bias that's driving a lot of this stuff over years? Yeah, there is. Like I said, this case, though it's seemingly about marijuana, it's about all of us. It's about how the system functions, how the system works, how the laws work, what's not working. It ain't working. Okay? What's going on now is not working. And I think that people are a little too comfortable with the dysfunction of it because they're at risk at any moment in time. Anyone can make up any conspiracy they want about anybody. And if you're violating federal law, you are guilty. And they're going to find their way to taking your assets, closing down your business, putting charges on you. And it's not hard to when all the evidence is your licensed business, what are you going to do? In that sense, here's what we did in Luke's case. And I think that we actually did a very good job with our defense. In 2018, as you know, the Farm Bill removed cannabis sativa L from Controlled Substance Act when its Delta 9 exclusive measurement was at or below 0.3%. What we discovered was that the DEA has a methodology that is not accepted by peer-reviewed science, international forensic standards, and even the government's own research funded by the Department of Justice identifies that the DEA's methodology, which is the gas spectrometer, which takes a sample of cannabis and in the lab runs it through an oven,
which will convert
of temperatures over 490 degrees.
Yeah, it will, through decarboxylation, convert it to a higher Delta 9 THC.
That's exactly right. So they take the sample, they run it through this thing, and heat is known to convert not only THCA 9, but CBD into Delta 9. And who knows how many other cannabinoids. We had a qualified expert. We qualified our expert on the stand, PhD, organic chemistry, 30 years working in cannabis plants, cannabis oils, the labs, the technology around that. Talked about the latest science, peer-reviewed science. CBD starts converting to THC at temperatures around 175 degrees Celsius at 30 minutes. So at 250 degrees Celsius, for up to 8 minutes, it's doing it a lot faster.
Yeah.
The government's research done by NIST, National Institute of Standards and Technology, their OSAC report came out in 2022, said this methodology must include a CBD conversion control, THCA conversion control, if it's non-derivativized, which is a fancy way of saying you didn't put a chemical on it to stabilize the cannabinoids before you put heat to it. So they're not doing that. And so what they're supposed to be doing is accounting for CBD conversion. And they're not. And all of their lab technicians admitted they are not doing this. They're not following those procedures. Why? Because that's our SOP is vetted and approved. By who? By the DEA, no one else. The DEA says our methodology is fine. Okay. But peer-reviewed science, academic science, international forensic standards, NIST all disagree. There's another methodology that all it does, and this is liquid chromatography, all that test does is tell you what's in the plant. It doesn't change anything in the plant. So you have an alternative method that is peer-reviewed, that is accepted in international forensic science as the gold standard. Now, here's what's funny. The U.S. attorneys put in their briefs that the reason they don't do this is it's too expensive. But what we got out on cross was, is it too expensive? No, we have it. What do you mean you have it? It's in the lab. You have the liquid chromatography equipment in your lab? Yeah. Do you use it? Yeah, we use it for every other controlled substance. Cocaine, heroin, methamphetamine, LSD. They're using it for all the controlled substances except cannabis. Why?
Because it throws the results off to make it more likely to be delta 9 THC and the decarboxyl.
Because they have a preferred outcome.
Right.
Because they like the results of the gas, the GC method.
Mm-hmm.
And that, I think, is one of the most consequential points that I want to share with others. It doesn't matter what you think about marijuana, whether it should be legal or not. You, as an American citizen, have to believe that the integrity at the center of our government is intact. And if you've got a methodology, a test, that can modify the results, can skew the results, can manipulate the results, can transform the results, can take something from legal to illegal, and that people can be punished for that, you know we've got an integrity problem at the center of government.
That should be
right
banned.
Where it matters
There's
the
no
most.
doubt that process should be banned in cannabis testing by these law enforcement agencies.
Absolutely. And so if there's any lesson that I think that needs to be shared and activists to get involved, think about the convictions since 2018 that have been sitting as a result of these positive tests. A positive test that manipulated results. And people said, oh, well, it says it's marijuana. How can I fight that? Right?
Right.
How
If you
can I
didn't
fight
know
that? Well,
the difference in the testing protocol, you wouldn't know how to counter it.
not only that, but think about this. The DEA certifies the private labs. All of those certified private labs are using the liquid chromatography test. So hemp farmers, hemp products, they are getting their stuff tested by the liquid chromatography test. Here's a very real scenario. If your liquid chromatography test says it's hemp, but it has a lot of THCA in it, what happens if we take that same sample and run it through the gas test? Will it convert? Could it take a legal hemp plant and turn it into marijuana? I think the answer is yes. I think that you could unintentionally be setting people up, that they're growing under the law, a high THCA test, a high THCA crop that gets certified under the liquid chromatography, which doesn't manipulate anything, so it stays under that 0.3%. If someone were to be found on that and they were to take it to their local lab, they're going to run it under heat. That thing very well could come back as non-hemp.
Mm-hmm.
Get above that 0.3% and perhaps even over 1%. And over 1% is where it's criminalized.
So that was something that you raised in pretrial motions, or was it?
This is all, well, we mostly address these things in the trial and cross.
Uh-huh.
And with our qualified expert who was able to provide a lot of insight into these things. Um, and it's the subject of our focus of some motions that we're preparing right now that we just got an extension on and we'll be filing by December 9th. So we're going to be really focusing the court on some pretty important black and white, black letter law, how criminal statutes are to be interpreted, and the gross integrity problem that the DEA's tests have, and we'll see what happens. But nonetheless, even the prospect of a test that can do what I'm saying, it should be thrown out. Even if it's possible, when we're talking about taking someone's liberties away from them, locking them up, it has to be 100% certain that your test is not manipulating results.
It's obviously true.
And
I think the
all
court should agree with that.
Yeah, we'll have to see what happens in that process.
So Luke and his father, Robert, have both been convicted under federal law. They're in Maine currently, and are they both facing a 10-year mandatory minimum sentence?
No, Luke is, and Robert is not. He was not quite as, he really shouldn't have been charged at all. It's highly, it's kind of gross what happened. But nonetheless, he was convicted as part of the conspiracy to distribute controlled substance marijuana.
I see. So they're both being held currently.
No, Luke is, Robert is not.
Okay. Well, Robert isn't. Well, thank goodness for that. What's the prospects for Luke now? What do you think the next step is? Is he going to get granted any sort of leniency by the court?
I can't tell you what the court's going to do. I can tell you that we're raising all the right issues, and that, as far as the court's concerned, I think that they have done a very fair job. They allowed us to present our case the best way we could. They put some limitations on us that were not unreasonable. But the same judge has heard this whole story. He was there for the evidentiary hearing. He knows what the complaint said. He knows about the cocaine for marijuana conspiracy that wasn't. So I'm hopeful that when we present with clarity what the laws say, what the role of the court is in these types of questions, his knowledge of all that, and I hope that his sense of balancing, the balance of justice, I hope that it comes out what I would say is the right way. But I'm not a judge. And I don't have to be that person that makes that decision. So we'll just see what happens there. But I think he's a very fair-minded person, and he gave us a chance to tell this story, and that's what you want in a court.
Mm-hmm. Yeah. So what do you think it was? Tell us about the prosecution in the case. How did they get a conviction even over this evidence?
Because they got a bunch of his former work colleagues and business associates to plead guilty to the federal charges, and all of them got up there as co-conspirators saying we were growing marijuana.
Mm-hmm.
We were growing marijuana.
But that's legal and licensed in Maine.
But that's not the defense, and they can't say that. We can't get into that. And so it really, I think that's what did it, is you had a bunch of people saying it was marijuana, but when confronted, all of them had to admit, no, we didn't test it, and no, I can't possibly tell you what was in what would each one measure at. And I did a fun cross on the DEA agent who had said out loud in court, this again, the top law enforcement for drugs said the following: I asked him, "You're aware that marijuana and hemp are the same plant, right?" And he said, "No, I thought they were two different plants." And I was astounded by that. I did not, I could not conceive of, you know, 2018. If we were doing the trial then, I could get you. We're in 2025, and you still don't know that marijuana and hemp are cannabis sativa L as defined in the Controlled Substance Act and the Farm Bill. You don't know that, and of course, doesn't know that they look the same and they smell the same. That a quote unquote hemp plant can flower. So he had to admit that he had no idea what he was talking about. He doesn't know how to identify marijuana from hemp. He also said something silly. The prosecutor showed him a picture of CBD, and he was like, and there's THC in there. And he goes, yes. And I get up there and I was like, a few minutes ago, you were talking to my colleague when he looked at some CBD pictures, and you said there was THC in there. How do you know that? Why are you saying that? I thought there was. You don't know that THC and CBD are two totally separate cannabinoids? What are we doing? And this is the reality. And I asked him, I said, weren't you trained in 2018 on the difference between hemp and marijuana? No. How about 2019? No. 2020? No. It's 2025. They still haven't trained these guys on the what you're looking at. And that's an important thing to recognize as well. Law enforcement is back in 1994.
Mm-hmm.
When they see a licensed business, they still think drug organization. They still see illegality. They don't understand the nuance between a cannabis plant that's federally legal and a cannabis plant that's not.
Mm-hmm.
They don't know that the brilliant people who understand that plant can develop genetics that have high CBG that are psychoactive with no delta 9 whatsoever.
And it looks and smells
They don't
just like
know
the
that.
high THC varieties. You
That's
won't
right.
know without a liquid chromatography test.
That's right. So here we are, and you got current events with McConnell putting in his hemp killer legislation in the last
Budget.
open up the government laws, which is nonsense.
Yeah.
He would rather recriminalize the plant than come up with comprehensive, common sense, regulated structure.
Right. Well, it's all about
to
money,
a plant.
and so.
Well, yeah, he's protecting his Kentucky bourbon folks and big alcohol, and we just need people like that to go away. We need the vast majority of public opinion is overwhelmingly in favor of reform, and it's really not that hard. I know inside the cannabis community there's divergence on opinions, but the reality is it's one plant. You've got to treat it as one plant. If you want to have high concentrations, that should be in your medical space. You want to have moderate, everyday cannabis stuff, that's your adult use. And you want your low dose things, there's your hemp. Pretty straightforward.
Yeah.
License it, regulate it, age gate it. Make sure that it's as clean of a supply as anything. No pesticides or all these things that are no good. Move on. Get over it.
Right.
Otherwise, what? What's the alternative? Let's go keep putting people in jail because they appreciate this plant.
Following the law, only to find out that they've been manipulated into violating it. That's a sad tale that Luke and his family are going through, and I appreciate you're there fighting that. We're down to about 5 minutes or so left. Tell us about the rest of your practice. You're in Virginia, New York, and you help with compliance issues in addition to these.
Yeah, we do a lot of things, inside the cannabis space, from branding, helping companies kind of turn the corner and legitimize themselves with a nice trademark work and a cool brand. Helping them with entering different markets, whether they're in the hemp beverage space, need label reviews and compliance and help on the distribution side. We litigate things, disputes happen, conflicts happen. So we go to court, federal and state court. As you may know, there's a lot of contraction going on in cannabis space nationally, a lot of M&A. And so we help, we do a lot of M&A work as well, a lot of transactional work. Yeah, so we're pretty well-rounded group.
And so it's the
And
Holston Law Partnership. Is that right? Partners.
hold on Law Partners.
Holton Law. That's Holton.
Yep. No T. Hold on Law Partners.
Okay. Well, thanks for clarifying that. Holon Law Partners. And that,
Yeah, you nailed it.
yeah, finally. Now that we're almost done with the show. If somebody wants to get in touch with you, Eric, what should they do?
Well, you can reach out to our website, holonlawpartners.com or holonlaw.com. And my email is pretty straightforward. First initial, last name, EPOSTOW at HOLONLAW.com. Or find me on LinkedIn. I put a lot of information on LinkedIn, and we're out here. We care about the community. We care about, holding the government accountable in these spaces. We have great relationships with government, with agencies, with administrators, and with businesses. And, we believe in, compliance first.
What states are you operating in?
Quite a few. Colorado, New York, Virginia, DC, Maryland, Texas, New Mexico, few other states, a lot of states.
Right.
Yeah.
Maine, obviously. You're there, at least in this criminal case.
Well, in this case, we're there.
Yeah. So is there anything you'd like to say in closing?
No, I think that, it's interesting that it's cannabis that allows for a real reflection of our system. Our system is broken right now in more ways than one. All anyone has to do is flip on the news and you can understand that we got a lot of problems here. But everyone across the aisle should expect integrity at the center of their institutions. And if we're going to have this bizarro world of federally legal and illegal in the same plant, a state legal of the federally illegal, then we've got to have a test at the center of that that's reliable, that's trustworthy, that's not manipulating the results. We ought to be demanding change about that. We should be demanding change about a lot of things, but they should no longer be allowed to use that test. It is unacceptable. That's intolerable.
All right.
So get the word out on that one.
Well, I appreciate you coming on and helping us with that, and keep up the good work there. Keep fighting for Luke. He obviously needs that. And I hope you can get that turned around. That's just a horrible thing. It bodes evilly for everyone in the cannabis space, for sure.
No doubt about it. Well, thank you so much. I appreciate all the work you've done. It's a great space, and someday we'll be on the other side of this, I think.
All right. Well, thanks for coming on. We've had Eric Postow at Holon Law Partners. I think I got it right finally. Thanks, and
Crush it.